Right now, somewhere in the world, there is an American citizen who has no idea they may already be on a path that could cost them their US passport forever. They believe their citizenship is permanent, unshakable, guaranteed for life. But the truth is far more complicated. Under US law, there are real, legal, and fully enforceable ways a person can lose American citizenship, even after holding it for decades. And many people don't discover this until it's too late. Imagine living abroad, making what seems like a harmless decision, taking a job, joining a program, signing an oath, and later finding out that single action put your citizenship at risk. Imagine believing you are protected by the Constitution only to learn that your own choices can undo that protection. This isn't fear-mongering, this isn't speculation, this is grounded in actual US law that exists right now in February 2026. Today, you're going to learn about 7 shocking but completely legal reasons someone can lose US citizenship. Some of them are obvious, others will surprise you, and a few might make you rethink decisions you've already made or are planning to make. If you are already a US citizen, this information could help you avoid a life-changing mistake. And if you are a green card holder working towards citizenship, understanding these rules is just as important because becoming an American is only part of the journey. Knowing how to keep that citizenship is the other half. By the end of this video, you will clearly understand what actions can put citizenship in danger, how the government evaluates those actions, and most importantly, how to protect yourself from ever facing this nightmare scenario. What you're about to hear could change the way you think about American citizenship forever. Hi, I'm Sofia, and if you care about your immigration status, your legal future, and your rights in the United States, you're in exactly the right place. Every day, I break down complex immigration and citizenship laws into clear, simple, real-world information, so ordinary people can understand rules that often feel overwhelming and confusing. Too many people assume that once they become American citizens, nothing can ever take that status away. Unfortunately, that assumption isn't always true. US citizenship is one of the strongest legal protections in the world, but it is not completely untouchable. There are specific situations written directly into federal law that can result in losing it. Most Americans never think about these rules until they are suddenly affected by them. That's why this conversation is so important. Whether you were born in the United States, naturalized years ago, or are currently on the path to becoming a citizen, understanding how citizenship can be lost is just as essential as understanding how it is gained. In this video, I'm going to walk you through each of the 7 legal reasons step by step in plain English with practical examples, so everything is easy to follow. We'll also talk about a powerful legal principle that protects most citizens from losing their status. A principle that runs through every part of this topic. My goal is simple: to make sure you never accidentally put your American citizenship in jeopardy because of something you didn't know. So take a deep breath, stay with me, and let's start unpacking what every US citizen and every future citizen needs to understand. Before we jump directly into the 7 reasons, there is something extremely important we need to understand first. Not all citizenship loss happens the same way. Under US law, there are actually 2 completely different legal paths through which someone can lose American citizenship. The first path is called denaturalization. This applies only to people who became citizens through the naturalization process. Denaturalization happens when the government proves in court that a person obtained citizenship illegally, usually because of fraud, lying on an application, or hiding critical information during the immigration process. That is a serious legal procedure initiated by the government, but that is not what we are focusing on today. The second path, and the one we are talking about in this video, is something called expatriation, also known as loss of nationality. Expatriation is very different from denaturalization. Instead of the government taking citizenship away because of fraud, expatriation usually happens because of voluntary actions taken by the citizen themselves. In other words, citizenship can be lost not because the government decided to punish you, but because of choices you personally made. The legal foundation for all of this comes from a federal law called the Immigration and Nationality Act, specifically Section 349. That section lists the exact acts that can result in losing U.S. citizenship. But here is the most critical point of this entire video, something you must remember as we go through every reason. Under modern constitutional law, American citizenship cannot simply be taken away without your consent. The U.S. Supreme Court has ruled that the government must prove a person intended to give up their citizenship. Intent is everything. That single word intent is the key that unlocks this entire topic. Performing one of the acts on the list is not automatically enough. The government must also show that you did it with the purpose of relinquishing your U.S. nationality. This legal protection is what prevents thousands of innocent Americans from accidentally losing citizenship every year. And as we move through the 7 reasons, you will see again and again how this principle shapes every decision the government makes. Now, let's begin with the first shocking reason someone can lose U.S. citizenship. This one surprises a lot of people because it seems so common and harmless on the surface. A U.S. citizen can lose their citizenship by voluntarily obtaining naturalization in a foreign country. In simple terms, if you are already an American and you later apply to become a citizen of another nation, that act can put your U.S. citizenship at risk. But this is where many people get confused. Just having dual citizenship does not automatically cause a problem. Millions of Americans legally hold 2 passports. Being born with citizenship in another country or inheriting it through parents is completely fine. What matters here is voluntary naturalization as an adult. If a U.S. citizen chooses to go through a formal process to become a citizen of another country, that can be considered an expatriating act under the law. However, once again, intent plays the central role. Under current State Department policy, the government does not assume that a person who naturalizes abroad wants to give up their American citizenship. In fact, the default assumption is usually the opposite, that the person wants to keep both. So when does this become dangerous? It becomes dangerous when the circumstances show that the individual clearly meant to abandon their U.S. nationality. For example, if someone applies for citizenship in another country and during that process makes statements rejecting the United States or declaring that they no longer consider themselves American, that can be used as evidence of intent. If they sign documents explicitly saying they renounce all previous allegiances, including allegiance to the United States, that can create serious legal problems. On the other hand, if someone becomes a Canadian or British or Australian citizen simply for practical reasons like easier travel, better job opportunities, or the ability to own property, and they continue to live as an American, keep their U.S. passport, pay U.S. taxes, and maintain ties to the United States, then there is usually no issue at all. The difference between those two situations is not the act itself, but the intention behind it. For green card holders watching this point is especially important. When you eventually become a U.S. citizen, you may still have connections to your country of birth. You might someday consider becoming a citizen there as well. That is not automatically forbidden, but you must be extremely careful to ensure that nothing you say or sign suggests that you intend to abandon your American citizenship. History shows that some people really have lost their citizenship this way, often because they did not fully understand the legal consequences of what they were doing. The lesson here is simple but powerful. Becoming a citizen of another country is not automatically dangerous, but doing it carelessly, without understanding how U.S. law views that decision, absolutely can be. The second reason someone can lose U.S. citizenship is closely connected to the first, but it deserves its own separate discussion because it happens more often than people realize. Taking an oath of allegiance to a foreign country can, under certain circumstances, put American citizenship at risk. On the surface, this might sound extreme, but in reality, many countries require some form of oath or declaration when granting citizenship, government positions, or even certain professional licenses. The key question is not simply whether an oath was taken, but what that oath actually meant and what the person intended when taking it. Not every foreign oath is treated the same under U.S. law. For example, if a dual citizen takes a routine citizenship oath in another country as part of a standard naturalization ceremony, and that oath is mainly symbolic or administrative, the U.S. government usually does not view that as an attempt to abandon American citizenship. Many people take such oaths simply because they want practical benefits like easier travel, the ability to work without restrictions, or the right to live permanently in another country. In those situations, there is typically no problem. But imagine a very different scenario. Suppose a US citizen takes an oath that explicitly says, I renounce all previous allegiances, including allegiance to the United States of America. Suppose they make public statements declaring that they no longer consider themselves American. Suppose they refuse to renew their US passport and begin acting in every way like a person who has permanently rejected their US nationality. In that case, the government may conclude that the oath was not just a formality, but a deliberate step toward giving up American citizenship. The State Department looks at the totality of circumstances in each individual case. They examine the exact wording of the oath, the context in which it was taken, and the behavior of the person afterward. Did the individual continue to live as an American? Did they keep filing US taxes? Did they maintain ties to the United States? Or did they take additional steps that clearly signaled a desire to break away from their American identity? Two people can take very similar oaths and end up with completely different legal outcomes simply because their intentions were different. This is why it is so important to be careful and fully informed whenever you are asked to swear allegiance to another country. Words spoken in an official ceremony can carry more legal weight than many people realize. The takeaway is clear. Taking a foreign oath does not automatically strip you of US citizenship, but doing so with the intent to reject America absolutely can. Understanding that distinction can save someone from making a devastating and irreversible mistake. Now, let's move to the third reason, one that often raises strong emotions and complicated questions. Serving in the armed forces of a foreign country can also lead to loss of US citizenship. This is an area of law filled with nuance, exceptions, and real-world complexity. Many people assume that any military service for another nation would automatically be considered a betrayal of the United States. In reality, the law is far more detailed and specific than that. The United States recognizes that Americans have deep family, cultural, and personal ties to other countries. Because of that, not all foreign military service is treated the same way. The most serious and dangerous scenario is serving in the military of a country that is hostile to the United States, especially if that service involves taking up arms against American forces. In such a case, the government may view the act as fundamentally incompatible with US citizenship. But what about serving in the military of an allied nation? Over the years, many Americans have served in the armed forces of friendly countries without losing their citizenship. For example, dual citizens have joined the militaries of close US allies for family or cultural reasons and have still kept their American nationality. The law looks carefully at several factors. Was the country an enemy of the United States or a close partner? Did the person serve as an ordinary enlisted member, or did they become a commissioned officer? Did they take an oath that rejected their US allegiance? And most importantly, did they intend to give up their American citizenship by joining that foreign military? Even the level and nature of service can matter. Serving briefly in a non-combat role is very different from becoming a high-ranking officer in a foreign military that opposes US interests. Once again, intent is the deciding factor. Without clear evidence that someone meant to abandon their American nationality, the government is unlikely to treat foreign military service alone as enough to take citizenship away. For green card holders, this issue often comes up in a different way. Some immigrants served in foreign militaries before coming to the United States. In most cases, that prior service does not prevent them from later becoming US citizens as long as it is properly disclosed during the immigration process. But for someone who is already a US citizen, choosing to join a foreign military is a decision that should never be made lightly. It is one of the clearest examples of an action that could potentially be interpreted as shifting allegiance away from the United States. The practical lesson is simple. If you are an American citizen and you are considering any form of foreign military service, getting professional legal advice first is absolutely essential. A decision made out of pride, family tradition, or opportunity could have consequences far beyond what you ever imagined. The fourth reason someone can lose US citizenship is one that almost no one thinks about until they are already in the middle of it. Accepting certain types of employment with a foreign government can, under specific circumstances, put American citizenship at risk. At first, this sounds strange. Millions of Americans live and work overseas. Many of them interact with foreign governments in one way or another. So, how could a simple job possibly threaten something as important as citizenship? The answer lies in the nature of the position and the intentions behind accepting it. Under US law, there are two main categories of foreign government employment that can be considered potentially expatriating acts. The first category involves accepting or serving in any office, post, or employment under the government of a foreign state when the person is also a national of that country or when the position requires an oath of allegiance to that foreign government. The second category involves taking a role that includes high-level policy-making responsibilities for a foreign government. In other words, the law is most concerned about situations where a U.S. citizen appears to be shifting their primary loyalty from the United States to another nation. But this does not mean that every job connected to a foreign government is dangerous. Far from it. A U.S. citizen working as a language teacher at a public university overseas, serving as a technical consultant, or even working as an administrative employee at a foreign embassy is usually not at any real risk. Those kinds of routine, non-political positions rarely raise any red flags. The situations that attract serious scrutiny are very different. Imagine a U.S. citizen who becomes a cabinet minister in another country, or a senior diplomat, or a high-ranking official responsible for shaping the policies of a foreign government. In those cases, the U.S. government may question whether that person has effectively transferred their allegiance. Even then, intent remains the crucial factor. The mere fact of holding such a job is not automatically enough to cancel citizenship. The government would still need to show that the individual accepted the position with the purpose of giving up their American nationality. Did they continue to present themselves as American? Did they maintain ties to the United States? Or did they make statements and take actions indicating that they now considered themselves solely loyal to another nation? These are the questions that determine the outcome. For most ordinary people, this rule will never become an issue. But for dual citizens, international professionals, and people deeply involved in global politics, it is something that must be taken seriously. Accepting a prestigious foreign government position may feel like a career achievement, but without proper legal guidance, it can carry hidden consequences. The message here is not to avoid working abroad or engaging with other governments. The message is to understand how U.S. law views those choices and to make them with full awareness. A dream job offer should never accidentally turn into a citizenship nightmare. The fifth reason for losing U.S. citizenship is the most direct and the most deliberate. It happens when a person formally renounces their American citizenship before a U.S. diplomatic or consular officer abroad. Unlike the other reasons we have discussed, this one is not about interpretation, context, or guessing someone's intent. This is a clear, intentional, and voluntary decision to stop being an American citizen. The process is very formal and very serious. To renounce citizenship, a person must appear in person at a U.S. embassy or consulate outside the United States. They must sign official documents, take an oath of renunciation, and make an explicit statement that they no longer wish to be a U.S. citizen. The government requires that this decision be made freely, without pressure, and with full understanding of the consequences, and those consequences are enormous. Renouncing U.S. citizenship is usually permanent and irreversible. Once it is done, the individual loses the right to live in the United States as a citizen, the right to vote in American elections, and the protection of a U.S. passport. In many cases, returning to the United States, even for visits, can become difficult or uncertain. There can also be serious financial implications. U.S. tax law imposes potential exit taxes on certain individuals who give up their citizenship, and former citizens may still have ongoing reporting obligations. So, why would anyone take such a drastic step? People renounce citizenship for many different reasons. Some do it because they want to fully commit to another country. Others do it because of complex tax situations. A few do it for political or personal beliefs. Whatever the motivation, the law treats renunciation as one of the most solemn decisions a person can make. Every year, several thousand Americans go through this process. But compared to the overall number of U.S. citizens, it is still extremely rare. For green card holders watching, this topic offers an important perspective. Many people spend years working toward the goal of becoming American citizens. They study for the test, pay fees, attend interviews, and finally take the oath of allegiance with pride. Yet, the law also recognizes that citizenship is ultimately a personal choice. Just as someone can choose to become American, they can also choose to stop being American. But that choice is not something to be taken lightly or made in a moment of frustration or confusion. Once citizenship is given up through formal renunciation, getting it back is extraordinarily difficult and in most cases impossible. The lesson is clear. Renouncing U.S. citizenship is always an option under the law, but it is an option with lifelong consequences. Anyone even considering such a step must think carefully, seek professional advice, and fully understand what they are about to lose. Citizenship, once surrendered this way, is rarely regained. The sixth reason someone can lose U.S. citizenship is one that very few people have ever heard about because it is rarely used in modern times. Under U.S. law, a person can renounce their citizenship while physically inside the United States during a time of war. Normally, as we just discussed, renunciation must take place outside the country at a U.S. embassy or consulate. That is the standard rule. But Congress created a special exception for extraordinary circumstances. During wartime, the law allows a U.S. citizen to give up their nationality from within the United States itself as long as the process follows very specific legal procedures established by the Attorney General. This provision was originally designed for situations where travel abroad might be impossible or dangerous, and where questions of national loyalty were especially sensitive. It reflects an older era of American history when global conflicts created complicated issues of allegiance and identity. Even though the rule still exists on the books today, it is almost never invoked. The process is heavily controlled, and the government has broad discretion over whether to even allow such a renunciation to take place. A person cannot simply walk into a government office and announce they are no longer American. Formal applications must be filed, investigations are conducted, and the authorities must be satisfied that the renunciation is truly voluntary and not the result of pressure, fear, or coercion. In practical terms, this pathway to losing citizenship is more of a legal safety valve than a common occurrence. Most Americans will go their entire lives without ever encountering a situation where this rule becomes relevant, but its existence highlights something important about U.S. citizenship law. The system is designed to cover every possible scenario, even the rarest and most extreme ones. Citizenship is a serious bond between an individual and a nation, and the law recognizes that in times of war, questions of loyalty can take on special urgency. For the average viewer, the main takeaway is simple. Unless the United States is in a declared state of war and you are actively seeking to renounce your citizenship through a highly formal process, this particular rule will never affect you. But it remains part of the legal framework, a reminder that the rules surrounding citizenship have been shaped by more than 2 centuries of American history and constitutional thought. The seventh and final reason is the most severe, the most dramatic, and the most morally serious of them all. A person can lose U.S. citizenship by committing treason, attempting to overthrow the U.S. government by force, or bearing arms against the United States. This category is fundamentally different from all the others we have discussed. The previous reasons generally revolve around personal choices, administrative actions, or formal legal procedures. This one strikes at the very heart of what citizenship represents. American citizenship is built on the idea of allegiance, loyalty, and shared commitment to the Constitution. When someone actively works to destroy the United States, wages war against it, or gives aid and comfort to its enemies, the law views that behavior as completely incompatible with remaining a citizen. In these extreme situations, intent is essentially built into the act itself. Unlike other expatriating acts where the government must separately prove that a person meant to give up their citizenship, acts like treason automatically demonstrate a rejection of American allegiance. The U.S. Constitution defines treason very narrowly. It includes levying war against the United States or providing aid and comfort to its enemies.